On behalf of the Sentencing Commission, Chairman Judge Robert Devlin, and our entire membership of the Sentencing Commission, we welcome you all here. Thank you, Dean Fisher of the University of Connecticut School of Law, for hosting us today, providing us with this beautiful, wonderful space in which to deliberate. Thank you to the partners of the National Center for State Courts and the Pretrial Justice Institute for providing the funding for the symposium. Here with our budget struggles in Connecticut, nice to have somebody providing funding, isn't it? That's great. Thank you, Patty Tobias, John Clark, Pam Casey. You know this event would not be possible without your support and help. Thank you very much. Thank you also again to my Sentencing Commission staff for spending days and days preparing this wonderful event and putting it all together. Alex Sarkoff, wonderful job. Hannah Horwitz, Ben Daigle, thank you very much for putting it on. You're doing a wonderful job. We appreciate it very much. And finally, thank you to all of you for your attendance here. Your care and your concern over this vital issue is how we're going to move the needle on it. We're so glad you're here, so glad you're with us, and we're looking forward to making great progress in this area. At the suggestion of the governor and also on our own initiative, the Sentencing Commission has been working on pretrial bail issues for now about 2 years. We've learned there are elements of our judiciary system that stand out as truly exemplary, and we have top-notch pretrial justice agencies and a validated risk assessment. However, just like most jurisdictions around the country, we're a wealth-based system that relies on money bail for release and detention decisions. There is a growing national recognition of the inequities inherent in the cash bail system. A number of us from the Commission spent some time this week down in New Jersey seeing how they do it down there. We've also been to Washington, D.C. and watched how they do it down there without bail. Poor people, most of the minorities, are harmed when, unable to afford even modest bail amounts for low-level offenses, they're locked up for extended periods of time. Often that leads to devastating personal losses, including loss of a job or inability to make rent payments, among other consequences of pretrial incarceration. More than that, there's a toll paid by our communities and victims. Even a few days in jails makes a low-risk person more likely to come out a higher-risk person and commit a crime in the near future. When we operate in a money-based system, defendants with money, even if they are dangerous, can purchase their freedom, while poorer defendants, who are not really so much of a threat to our public safety, remain in jail. Are we okay with that? I don't think so. I don't think so. So again, thank you for coming here today and addressing these issues and coming to it. Systemic change is rarely easy, but replacing money bail seems possible. Numerous national and local initiatives to replace money bail with risk-based practices are already underway, and we're going to talk about that today. I would like to now welcome to the podium Dean Timothy Fisher, University School of Law, to give his personal welcome to you for today's event. Dean, please.
Well, good morning and welcome, everyone. This is a wonderful occasion for the University of Connecticut School of Law. We are the law school of the state of Connecticut. We are supported by you, our taxpayers, and we honor our opportunity to be the location that explores the intersection of law and public policy. And at this moment in our country's history and at this moment in our state's history, there are few issues more important than criminal justice reform. And we have been so fortunate to host not only this, but 2 years ago, the governor's announcement of his Second Chance Society here at one of our symposia in November of 2015. And so thrilled that we can be the center of that kind of conversation. The law and the exploration of the law is at its heart an effort to be both rational and consistent with our values as a people. And when you apply that to pretrial criminal justice and pretrial detention in particular, it's not hard to identify what our principles, our guiding principles, should be. And I believe there's near universal recognition that the goal of any pretrial detention system should be, number one, minimize detention. Number two, minimize safety risk to the defendant, him or herself, or to others. And number three, minimize the risk of non-appearance for trial. And any system should try and balance those three goals. That much we should agree upon without difficulty. And indeed, Connecticut is better than most parts of the country. About 25%, I believe, of our detained population is pretrial as opposed to sentenced. Most of those are accused of felonies. And with the legislatures and the governor's leadership of last year, there are more reforms underway. But still, we have a problem. And the problem is money bail. Because why on earth should one's financial resources govern the outcome of those three questions: minimizing detention, minimizing safety risk, and minimizing non-appearance? What money bail does, as Mr. Chairman Santa just mentioned, is it basically says, well, if you're a flight risk and you're dangerous, we'll let you out because you're wealthy. And if you're not a flight risk and you're not dangerous, we're going to put you in prison because you're not. There is no rational basis for that arrangement. It harms the defendant, it harms the defendant's family, it harms the defendant's employer, it harms our entire state and society, and it hurts us as taxpayers. And along the way, for those who are able to post bail and get out, it constitutes a massive wealth transfer from the working poor and the poor to bail agents and the companies that issues these bonds. And I believe, and others will discuss this, there is virtually no correlation between the amount of bail posted and someone's safety risk or their likelihood of appearance. So what does this tell us? Too many laws in this country are made or continue to be enforced based on anecdote and irrational fear. And it's our obligation, and believe as in a law school, as a leader of bringing the next generation of lawyers into our country, I'll come back to my opening points. A system of laws should be rational, and it should be consistent with our values. And I look forward to this tremendous program today that's going to explore what's the best path forward for us. So with that, we are thrilled that you are all here, and it's now my opportunity to ask Judge Robert Devlin, the Chief Administrative Judge of the Criminal Division of Connecticut Superior Court, who will introduce our keynote speaker.